into a disciplinary action. So please make sure that we are all on the same page, right? Yeah. Thank you. Okay, that's fine. You can ask them. Shambhavi. Kindly please be seated. A very good morning to one and all present here. We all have gathered here for the open discussion and the launch of the Center for the Promotion of International Law, Vinayaka Mission Law School's flagship journal, the VMLS International Law Review. We bring before you three eminent scholars of international law who have been making some crucial contributions to the legal field. We are a day away from celebrating Constitution Day and a couple of days away to celebrating International Human Rights Day. The occasion demands us to reassert what Eleanor Roosevelt said, and I would like to quote, "Where, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps of the world, unless these rights have meaning here and there. They have little meaning anywhere. Without concerned citizen action, upholding them close to their homes, we shall look in vain for progress in the larger world." I, Nabila Siddiqui, and my colleague faculty coordinator, Professor Shambhavi Thakur, Assistant Professors of Law, take the pleasure on behalf of the Center for Promotion of International Law, CPIL, and the Vinayaka Missions Law School, Management and Faculty for welcoming everyone who's present here to the open discussion commemorating 75 years of UDHR. I would now like all of us to rise for the Tamil Thaivarthu.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் மதனமென நிகழ்வத கண்டனிதில் கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் சிறு திரை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறந்து எந்து செயல் மறந்து வாழ்த்ததுமே வாழ்த்ததுமே
I would now like to request our Dean, Professor Anant Padmanabhan, Professor Prabhash Ranjan, Professor Bharti Kumar, Professor Archana Negi, and Professor Shambhavi Thakur to light the lamp. Now, I would like to invite our Dean, Dr. Anant Padmanabhan, to felicitate Dr. Prabhash Ranjan. I would like to invite Dr. Sarina to felicitate Dr. Bharti Kumar. I would now like to invite Professor Gunjan Saxena to felicitate Dr. Archana Negi. Now, let me take a moment to introduce you to the anchor of our strength and the visionary leader of Vinayaka Mission's Law School, our Dean, Dr. Anant Padmanabhan. His invaluable wisdom served as wellspring of inspiration for all of us. reinforcing the profound significance of our dedication to achieving excellence. Requesting Dr. Anant to deliver and throw open the event and speak a few words. Over to you.
Thank you, Professor Siddiqui. Good morning, everyone. Let me begin by welcoming our guests for this special occasion. Dr. Prabhash Ranjan from South Asia University, Dr. Bharti from NLU Delhi, and Dr. Archana Negi from JNU, all three of the finest institutions in our country, for taking time out to be here to throw open our Center for Promotion of International Law and for the inaugural ceremony for our Vinayaka Mission's Law School International Law Review. I really take great delight in welcoming you all today to this solemn occasion, which has been made possible by the great effort put in by two of our faculty coordinators, Professors Nabila Siddiqui and Professor Shambhavi Thakur. Thank you both for this. And of course, all my faculty colleagues who have worked really hard, all our non-teaching colleagues who have worked really hard, and of course, all of you students who volunteered to make this event a possibility. This is also an interesting occasion because we stand here to mark the 75th anniversary of the Universal Declaration of Human Rights. We stand here on a day just on the eve of the Constitution Day, and of course, with the realization of various realities around us, one of which had led in the first place to the VMLS International Law Review. And that is the war that still goes on in Ukraine. Back then, of course, when the war broke out and we thought about coming out with this law review, nobody thought that there will be a second war soon. But what we see every day is, I'm sure, fairly shocking. It shocks our conscience. And we understand today that while international law frameworks have largely come about in response to these harsh realities, we do not have perfect solutions in the world that we live in. So I cannot really think of a better panel than this distinguished gathering of three academics, very respected, fearless academics from three of the finest institutions in the country to deliberate on this. I really would like to start with a disclaimer that I'm not an expert in the field of international law. I could well have been one of those who ignorantly remarked that opinio juris is indeed the opinion of the jurists, a long-running joke at my alma mater, the National Law School of India University, Bangalore, and I suspect in other law schools as well, for those of us who find international law very tough to navigate as a field of law. However, there are three aspects about international law which have always struck me as very remarkable and which I would like to take a few minutes today to share with each of you. And I think those are very important too for us as we create the blueprint for what we are trying to do here at Vinayaka Mission's Law School. We claim and we believe that we can create the law school of the future, but then if you're doing that, I think engagement with these three aspects of international law become absolutely important. So in a nutshell, these three elements are the vision of this very field of international law and what that entails, the institutions that have been carved out or shaped or created in order to perpetrate that vision or advance that goal, and the role of legal academics, because this is a very unique area, and I'm going to speak a little bit to that later, in shaping norms, in weighing on the trajectory of law and how that evolves in this space. So the first, the aspect of vision. And what I find amazing about international law is the very elegance of that vision. And why is it so elegant? I mean, it's just interesting to me that a whole body of law has come about from multiple sources with great discussion that rages on what the weight and credibility of each of these sources are to govern essentially the behavior of nation states. Isn't that truly fascinating and truly elegant? The fact that there are nation states with all kinds of variations of history, culture, governance systems, political leadership, and then you're trying to get all of them aligned on a common set of values and norms. That vision is truly something very remarkable. And to me, it is part of a grand balancing exercise between power and principle, stability and change, interpretive rigor and policy foresight, and that makes this the field burnish bright, the elegance of this field burnish bright. And that's something that I find very, very unique and special about international law. This aspect of balancing has also created complexity of institutions that have come about. And we face a lot of critiques when it comes to these institutions. They are more often than not accused of being partisan in their outlook, non-representative in their real vesting of decision-making authority. All of us can give a throwback to the Security Council here. They're considered sometimes to be hegemonic or overtly tilted towards existing power structures in their philosophical moorings. And above all, often you hear that they're toothless, that they really can't actually bring about any change because they have very little enforcement power. So it's the rule of might. Sure, we have heard all these critiques, but I would request each of you to reflect for a moment as to what we have managed to achieve despite these critiques and criticisms, right? Since the time of the Second World War, these institutions have served as sites of contestation for competing value propositions and policy visions. They have also, with varying degrees of pace, set and shaped the world order through both participatory and top-down decision-making and general and specialized forms of adjudication. But most significantly, through pandemic and war, liberalization and inshoring, civil strife and truth-telling, these institutions have displayed a remarkable streak of resilience. So resilience is something that really has marked out these various institutions that today stand as the bulwark of enforcing these norms and principles that we come to understand as international law. The third aspect, as I already mentioned a brief while ago, is the value placed on academic work in this field. And this is perhaps fueled by the scope for extensive critique against vision, values, and institutions offered by the field, simply on account of its origins. Be it a James Crawford or a Rosalind Higgins or our very own, the late Dr. V.S. Mani, there are many international law scholars who have shaped the trajectory of the law and continue to do so in ways more influential than is the case in many other areas where the practitioner-academic distinction is far more acute. Many of the international law scholars write and practice in their respective areas of specialization. Gary Bond, a prized academic from another alma mater of mine, UPenn, comes to mind here. And they weigh in on matters ranging from the law of war to climate change to outer space treaties. So this is all great, and these are three very important features of the field that I thought I should highlight on this occasion. However, despite the elegance of vision, resilience of institutions, or the prominence of academics, international law study has taken a backseat for some reason. Even in places like Chennai, known once for its galaxy of academic superstars in this area, at one point not too far back in time when the city was officially Madras. We've had doyens of international law in this very city, and yet today the work on international law has, in our view, dwindled significantly as far as the city is concerned. Therefore, when setting up our Center for Promotion of International Law, we at Vinayaka Mission's Law School, we were clear that this is as much a moment for research and reflection as it is a moment for revival. And I say that this with all the humility expected from someone like me, an institutional leader heading a relatively young law school with far more aspirations than track record in our story thus far. Yet, we firmly believe that institutions like ours can and must play a role in this revival of thinking about international law, aspiring as we do to become the law school for the future. So a new blueprint for teaching and learning international law, which doubles down on the vision, institutions and scholarship in this field is highly needed. And from our limited experience, it must start with critiquing the ramparts of power and hierarchy that the existing institutions represent, so that the problems of tomorrow or even today, be they artificial intelligence, climate change, or rising inequality, they find more representative and inclusive responses. The study of international law must also contextualize the learning of the subject and figure ways to connect the domestic with the international, I believe, a topic on which Dr. Prabhash Ranjan has much to share today with all of you. Finally, it must provide a sense of career pathways and possibilities too for those interested in the field. To do all this and more requires a collaborative project and a range of ideas across the spectrum. And we hope our Center for Promotion of International Law serves as an excellent crucible or incubator for this grand plan. I will now join you all in witnessing the unfolding of that plan through the perspectives of our distinguished guests here today. Thank you all very much for your kind audience. Thank you.
Thank you, Dr. Anand. You have very crisply thrown light on some of the prospects and challenges in the field of international law. Now, I would like to introduce you to our chief guest, Dr. Prabhash Ranjan. His commitment and scholarship is not unknown to the fraternity. Professor Prabhash is an associate professor at the Faculty of Legal Studies, South Asian University. He worked as professor and vice dean, Jindal Global Law School, OP Jindal Global University, while on leave at South. Previously, he taught at NLU Jodhpur, NUJS Kolkata. He holds a PhD in law from King's College London and is also a visiting professor at NUJS Kolkata. Professor sits on the editorial boards of some of the most reputed international journals. As an external consultant, Professor Prabhash has handled various projects from key UN organizations and also from other prestigious organizations like the Center for WTO Studies, IIFT, Federation of Indian Chambers of Commerce and Industry, Linklaters, University of Pennsylvania's Center for Advanced Study of India. He has authored a book, India and Bilateral Investment Treaties, Refusal, Acceptance, Backlash, published by Oxford University Press. Professor has written over 70 research articles in peer-reviewed journals and edited books, and more than 175 op-eds in leading national newspapers like The Hindu, The Hindustan Times, The Indian Express, and according to Google Scholar, his work has been cited over 600 times. Summing up this formal introduction, I would like to personally add that I know Professor Prabhash in capacity of an avid reader who cannot start her day without reading the op-eds of The Hindu, where Professor Prabhash contemplate and contribute on the contemporary issues of international law in the most simplest terms. Over to you, Professor.
Thank you very much for that very warm introduction, Nabila, which I don't deserve, but thank you very much. And I'm extremely grateful to Vinayaka Mission Law School for this kind invitation. And many congratulations to the law school for starting the Center for Promotion of International Law. I completely agree with Dean Anand that Chennai has been, or Madras, as it was earlier called, has been the place where international law has flourished. And therefore, it is very befitting that the Vinayaka Mission Law School is starting a Center for the Promotion of International Law, which I hope and sincerely hope that it will make a useful contribution to the study of international law. So before I come to the topic, let me just sort of make a very general remark about international law inspired from the comments that Anand made. International law undoubtedly is passing through a crisis. And while we celebrate 75 years of UDHR, which according to me in essence means celebrating or critically examining the field of international law as well, Just a few days back, a student of mine in the class asked that why should we really study international law? No one thinks that it is law, right? Sovereignty of nations, which all professors will tell you in the class, is the founding principle of the UN Charter, is nothing but a myth, right? All sovereign nations are not equal. Look at what is happening in the Russia-Ukraine war. Look at what is happening between Israel and Hamas. And you see violations of international law left, right, and center. So is it really law? And my response to that question was in the form of a question that in the Constitution we have equality of all Indian citizens. But in reality, are all Indian citizens equal? We all know the answer, right? Now, just because there is no equality in the real sense, that does not mean that we stop talking about equality in the formal sense. So equality of citizens is an aspirational value, and likewise equal sovereignty of nations is also an aspirational value. All nations may not be equal today, but that is what they have to be in the future, and that is the goal that as students of law, as students of international law, we all need to work about. Okay, now I'm going to talk about a specific topic, and the organizers were very generous in allowing me this flexibility. So while we celebrate 75 years of UDHR, and which in a broader sense I would say celebrating human rights, celebrating international law that recognizes human rights, universal human rights of all people all over the world, it is equally pertinent to see that how international law has been received or has been taken by our domestic courts. Now it is in this regard that I have been doing some research. And I'm not the only one who has done research on this. There are many others who have done research on this. But I've specifically looked at how the Indian Supreme Court has dealt with international law. And whether the Supreme Court has been able to develop coherent jurisprudential principles in order to understand international treaties, customary international law, or other principles of international law. So I'm going to talk about this in my presentation. And let me... Okay, yeah. So let me start by saying that since we live in a globalized world, although there are now talks of deglobalization and stuff like that, but I still think that we live in a globalized world. And given this globalized world, the encounter between international law and domestic law has increased, and going forward, it is only going to increase. So in other words, even if you don't like it, even if you want to make a career in purely domestic law, you will be facing international law questions. You will be facing situations where you will be looking at a domestic law principle from the prism of international law. And this is precisely what has happened with our courts as well. In the last 30, 40 years, you will see that there have been umpteen cases where the Supreme Court was confronted with situations of looking at domestic law issues through the prism of international law, or using international law as a tool to understand or to throw light on a principle of international law. So if we look historically, and this is something which I'm sure you must have studied in your international law course as well, there are two schools of thought which tell us about the relationship between international law and domestic law. On the one hand, we have the principle of dualism, which basically means that you will have to international law will become part of domestic law only if it undergoes a process of transformation, which means that international law on its own is not part of the domestic legal system unless or until the parliament of that country or the legislature of that country has enacted a law to give effect to that international treaty or international principle. This is the principle of dualism, and this has played a very important role in our Indian system as well, as I will talk about. And then you have, on the other hand, the theory of monism, which basically considers that international law and domestic law are an inseparable legal framework. So according to the monist school of thought, international law is part of domestic law. The moment a country signs an international treaty, that international treaty automatically becomes part of the domestic legal system of that country. Now, given these two schools of thought, and which are quite old, some scholars have argued that this lens to understand the relationship between international law and domestic law is archaic, it's outdated. It does not make any sense in the current era in which we live, because you will struggle to find a country which is purely dualist, and likewise you will struggle to find a country which is purely monist. So even countries which are considered to be monist, such as United States, you might come across examples which reflect the dualist tradition. Likewise, as I will talk in my presentation, countries which were considered to be dualist theoretically have started to move towards monism. So therefore, this distinction does not make sense anymore, and therefore it's out. This is not the right conceptual lens to understand the relationship between international law and domestic law. There are also examples of new frameworks which are coming up to understand the relationship between international law and domestic law. And one such framework is of populism. So what has happened in the last decade or so is that given the rise of right-wing populist leaders all over the world, be it Donald Trump or be it many others, there is a school of thought which basically says that the populists believe that foreign law should not influence domestic law, and they look at international law as foreign law, as not something which is homemade, homegrown, right? And therefore, international law should not play any role in influencing or interpreting domestic law. And this has become a very popular framework which scholars are adopting to understand the relationship between international law and domestic law. However, in my paper and in my research, I stick to the dualist monist framework for the very simple reason that our Supreme Court still follows this framework whenever it has to interpret or understand the relationship between international law and domestic law. And therefore, I'm going to follow the dualist monist framework to understand what the Supreme Court has done or what it has been doing in the last several decades when it comes to international law. Okay, now very quickly, I'll want to take you through the framework that we have in India. I'm sure this is something which all of you have studied and you know about it. Where do we find references to international law in the Indian Constitution? So to start with, you have Article 51C of the Constitution, which says that the state shall foster respect for international law and treaty obligations. You will find several cases of the Supreme Court. Whenever the Supreme Court has referred to international law, it has always referred to Article 51C as the entry point, as the port through which international law can enter the domestic legal system. Apart from Article 51C, you also have few other articles. For example, if you look at Article 246(1), which says that notwithstanding what is contained in clauses 2 and 3, the Parliament has exclusive power to make laws for any of the matters enumerated in List 1 in the 7th schedule. So the Parliament has powers to make laws on topics given in the Union List. And if you look at entry 14 of the Union List, entry 14 of the Union List specifically talks about entering into treaties and agreements with foreign countries. So signing international treaties is a topic which falls within the Union List, and therefore the Parliament has the power to make laws on entering into treaties and agreements with foreign countries. Likewise, we have Article 73(1)(a), which provides that subject to the provisions of the Constitution, the executive power of the Union shall extend to the matters with respect to which Parliament has power to make laws. So in other words, the executive power is coterminous with the power of the Parliament. The executive can also enact laws or make laws or enact policies on topics which fall as part of the Union List. And then finally, we have Article 253, which gives Parliament the power to enact a law even on a topic which is in the state list in order to implement an international treaty. So if there is an international treaty on, say, agriculture, and agriculture happens to be a topic in the state list, the Parliament has the power to make a law in order to implement that international treaty. Now, if we take all these provisions together, the picture that we get is that our constitution makers wanted India to be a dualist nation. They said that international law on its own will not enjoy the force of law domestically unless or until it has been transformed into a domestic law by the Parliament. And if we look at how the Supreme Court has dealt with treaties to start with, before I come to customary international law, we can divide this journey into 4 stages. And I call the first stage as the early days of dualism. Then I look at the second stage where I show that over a period of time, the court started to move away from the doctrine of dualism or transformation and started judicially incorporating international treaty law into the domestic legal framework. Then in the third phase, I say that notwithstanding this shift away from dualism, there are also a string of cases which show that the principle of dualism kept coming back or kept rebounding. And finally, I look at that phase or those string of cases where the Supreme Court started to incorporate even those treaties which India has not signed. And this is very interesting. Okay, so let's start with the early days of doctrine of dualism. Now, there was this very famous case, I'm sure you must have read this in your class as part of your coursework, Maganbhai Ishwarbhai Patel versus Union of India, a 1969 case, one of the founding cases when we look at the relationship between international law and domestic law. And in this case, the court said that under the Constitution, the obligations that arise under the agreement or treaties are not by their own force binding upon Indian nationals or others. Accordingly, the power to legislate in respect of treaties lies with the Parliament, and enacting a legislation is necessary when the international treaty restricts the rights of citizens or modifies the laws of the state. So the court basically reaffirmed the principle of dualism in the Maganbhai Ishwarbhai case. Likewise, if you look at several other cases, for example, another case known as Jolly George Verghese versus Bank of Cochin, the Supreme Court of India, once again in this case, laid down the principle of dualism, saying that international treaty will not have a force of law unless or until it has gone through what is known as the process of transformation. Coming to 2004 and leading up to 2004, you find the principle of dualism finding references in Supreme Court decisions. This case known as State of West Bengal versus Kesoram Industries, where once again the Supreme Court laid down the dualist principle. Now, if we look at this string of cases, it gives an impression to you that India is still faithfully, religiously implementing the constitutional mandate, which is that an international treaty has to be converted into domestic law. But if we look at another set of cases, and these are the cases which involved human rights, and some of these cases actually looked at the UDHR as well, we will find that there is a move away from the doctrine of transformation. So, for example, if you look at a case known as Gramophone Company versus Birendra Bahadur Pandey, which was decided almost at the same time when you had Jolly George Verghese. In this case, the court said that in the Committee of Nations, it requires that rules of international law may be accommodated in the municipal law, even without, and this is something important, even without express legislative sanction. So the court is saying, for the first time perhaps, that international law will be part of domestic law even without an express legislative sanction, provided, and there is an important caveat, that the international law does not run into conflict with acts of parliament. So if there is an international treaty which is not inconsistent with any law that the Indian Parliament has enacted, right, which is not inconsistent with law of the land, that international treaty will be read as part of the Indian legal system. And this is quite profound because this is not really the dualist principle, this is actually the monist principle. And then you will find several cases where this monist principle has been followed. A very important case, which I'm sure all of you know, is Vishakha versus State of Rajasthan, the case which laid down the law to protect women from sexual harassment at workplace. We all know that, we finally got a law on this in 2013. Till 2013, there was no law enacted by the Parliament which protected women from sexual harassment at workplace. And for all these years, the law was, which was laid down by Supreme Court in the Vishakha judgment. And if you read the Vishakha judgment, you will find that Justice Verma, the Chief Justice Verma, he referred to several human rights instruments, including UDHR, in order to give the law on protecting women from sexual harassment. And it was again a very important case of monist incorporation of international law, not the dualist transformation that the Indian Constitution talks about. But we also see, along with these cases, that dualism keeps rebounding, right? And this is where the inconsistency lies, and this is what we need to debate. That while on the one hand, the Supreme Court is talking about monist incorporation, but on the other hand, there are several cases where dualism keeps coming back. And this is, up to 2004, as I mentioned earlier. And then if you look at other cases, for example, there's a case which I want to talk about. This is a case in 2020 known as Union of India versus Agricus, where again the principle of dualism was incorporated. And more recently, something which I have not been able to update in my presentation or in my research, more recently, the Supreme Court, while it was interpreting tax treaties, the double taxation avoidance agreements and the MFN principle in it, Justice Ravindra Bhatt, one of his last judgments before he retired from the Supreme Court, there again the court said that double taxation avoidance agreements can only be implemented in India if they have been incorporated into the Indian domestic law. So if they have not been incorporated into the Indian domestic law, then no relief can be given to any SSE under the double taxation avoidance agreement. So we see again the principle of dualism making its entry. Now, finally, in terms of dealing with treaties, I want to briefly talk about those instances where the Supreme Court has dealt with those treaties which India did not sign. And this is something which is very important because many scholars have argued that if a country has not signed or not accepted an international treaty, and even if that country is a monist country or follows monist incorporation of international law, how can those international treaties form a basis of becoming part of the Indian legal system, right? Because these are treaties which India has not signed. But if you look at the work of Lavanya Rajamani, for example, she has talked about some cases, especially environmental law cases, which I presume my colleagues might talk about, where the Supreme Court has said that even those principles which are not readily recognized as hard law, international law obligations are binding on domestic courts. And this is something which is very fascinating. Okay, now given the paucity of time, I'll move forward and I'll briefly look at customary international law and how courts have dealt with customary international law. And this is where I find that the Supreme Court's dealing with customary international law has been even more confusing or even more perplexing in comparison to international treaty law. So if we look at, we all know, notwithstanding the joke that Anand shared, that customary international law becomes law only if it satisfies two conditions, that is state practice and opinio juris. So which means that there should be a consistent state practice and states should have been following that practice with the belief that this is part of their legal obligations. Now, if you look at the work of critical international lawyers, for example, if you look at the work of Professor B.S. Chimney, he has been very critical of the manner in which certain principles attain the status of customary international law. And if you look at state practice, for example, mostly it is the state practice of Western countries which plays a critical role in saying that something has become part of customary international law. The state practice of developing countries or third world countries perhaps is not given the kind of attention that it deserves. And therefore, to say that something is part of customary international law always has to be taken with a pinch of salt. You need to critically examine that whether this is indeed part of customary international law. And if we look at the history of international law, we will find that several principles which perhaps suited the Western powers, these principles have been recognized as part of customary international law. And, the Western world is very good in producing knowledge and in propagating knowledge, something that third world countries are yet to learn or they're still learning. And the process always starts by the state doing certain things and then the academic community joining them and helping in propagate that principle or that value till the time it is almost taken as a given that this has now become part of customary international law. So I'm talking about this background because the Supreme Court of India hasn't dealt with customary international law with this kind of rigor. And this raises questions about whether, customary international law principles, how readily they should be incorporated into the Indian legal system. So I want to talk about, a few cases, and one important case here is which was recently decided by the Supreme Court a few years back, known as Muhammad Salimullah versus Union of India. Now, this was a case which involved the deportation of Rohingya refugees. As you all know, Rohingya refugees have been facing persecution in Myanmar, and the question was that whether they can be deported back to Myanmar. And the Supreme Court in this case demonstrated its relationship or demonstrated its uneasy relationship with customary international law. Now, the court in this case basically said that, India is not a signatory to Refugee Convention. Now, if you look at the Refugee Convention, if you look at Article 33(1) of the Refugee Convention, it gives us the principle of what is known as the principle of non-refoulement. Now, non-refoulement is a principle where, a refugee cannot be sent back to a country where the refugee is facing persecution. This is recognized as part of customary international law globally, although there are some instances where some scholars say this is not part of customary international law. But interestingly, the Supreme Court in this case held that these refugees can be deported back. And they said that the principle of non-refoulement is not binding on India because India is not a signatory to Refugee Convention. While India is not a signatory to Refugee Convention, that's right. But what about the principle of non-refoulement as part of customary international law? If it is part of customary international law, then it is binding on India as well. Now, the court completely sidestepped this question. The court did not deal with this question that whether this is a principle of customary international law and whether it is binding on India. Now, court could have held that this is not a principle of customary international law, for example, and therefore it is not binding on India. But the court did not discuss this aspect at all. And therefore, I say that this is the uneasy relationship that the Supreme Court has with customary international law. When it suits, it refers to customary international law in order to interpret a principle. When it doesn't suit, it completely sidesteps and ignores customary international law, which then gives rise to question that whether it is dealing with international law in a robust manner or not. Okay, finally, so what is the conclusion? Well, I'll list down 4 conclusions for you. Firstly, that while the normative framework given in the Indian Constitution on the relationship between international and domestic law is that of dualism or doctrine of transformation, the Supreme Court of India, broadly speaking, has departed from the principle of dualism. Second, notwithstanding this broad movement towards the monist incorporation, you still find jurisprudence emerging from the Supreme Court, which is riddled with inconsistencies. And as I have discussed in my presentation and my research, you still find cases where dualism keeps coming back and the dualist principle is being talked about. What is very interesting is that in all those cases where the Supreme Court talks about the principle of dualism, it completely overlooks the cases where the monist incorporation was followed. So if you look at Union of India versus Egregious case, for example, there is no reference to Vishakha case there. There is no reference to any other case. There is no reference to Puttaswamy case, which also, in a way, reflected the monist incorporation. And likewise, if you look at the other string of cases, there is no reference to these kind of cases. So it almost appears as if there are 2 parallel tracks running in the Supreme Court dealing with international law. And depending on the facts of the case, the Supreme Court seems to be jumping from one track to the other. The Supreme Court, conflictingly, has also incorporated international treaties that India has not signed, as I mentioned, and this is a very important critical aspect that needs to be explored. And finally, in the process of incorporating customary norms under international law, there is a flaw in the court's methodology. Whenever the court has said that something is part of customary international law, you will rarely find the Supreme Court dealing with the principle that whether this is indeed customary international law. As I said earlier, that is a very important issue. There is a very interesting paper of Professor Chimney that all of you should read, published in American Journal of International Law a few years back, where he has critiqued this entire process of formation of customary international law. And we would expect our Supreme Court to be more engaging with this particular aspect rather than be so deferential to what the Western scholars are saying on this issue. So I'm not saying that the Supreme Court should not take into account customary international law, but there has to be a greater level of critical engagement with that principle before it is implemented, incorporated, or rejected or discarded in the interpretation of domestic law. So I'll conclude by saying that there is a lot of scope for the Supreme Court to improve its methodology in dealing with international law. There has to be a greater robustness. If you may ask, what are the reasons behind this? I think the reason is that perhaps international law is not taken as seriously as it should be, both by practicing lawyers and by our judges. And this needs to change. And therefore, I said at the beginning of my presentation that even if you want to make a career purely in domestic law, even if you want to become a constitutional lawyer or administrative lawyer, you cannot escape the fact that international law will play a role in whatever you are doing. And therefore, a sound and a good training in international law is a very important element for you to become a complete and a comprehensive lawyer. So with these words, I end, and I thank all of you, and I thank the organizers once again for this wonderful opportunity and for their generous hospitality. Thank you very much.
This brings us to a quotation by Henry Adams. And Henry Adams very aptly says, "Chaos was the law of nature. Order was a dream of a man." Thank you for an exceptionally informative talk, Professor. Now, I would like to invite my guru, mentor, and one of the most humble lady I came across in the legal fraternity, Dr. Bharti Kumar. Dr. Bharti is a professor at National Law University, Delhi. She joined NLUD in 2009. She has a long experience of teaching law since 1998. She has been a student of Delhi University and has taught at the Faculty of Law, Law Center 1 and Law Center 2 DU. She has been a visiting faculty at Indian Law Institute, Institute of Constitution and Parliamentary Studies, Bureau of Parliamentary Studies and Training. She has published several articles and made presentations on various topics of law. She has coordinated several workshops and seminars at DU and NLUD. She is involved as the faculty coordinator for legal aid activities at NLUD. She is involved in teaching clinical papers pertaining to legal aid, court management, and professional ethics. She has been a regular visiting faculty at Bureau of Parliamentary Studies and Training BPST, Institute of Constitutional Parliamentary Studies ICPS, and the Haryana Institute of Public Administration. She is on advisory board as a part of the editorial boards of various educational institutions. She has various articles published in her name, several paper presentations on different themes. She has been the faculty coordinator for MOOC courses on environmental law and has had a wide subscription across the country. She is also the director for Center for Environmental Law, Policy and Research, NLUD, and has conducted various initiatives in environmental law, including teachers' training program on environmental laws and workshops. Over to you, Professor.
Thank you very much, Nabila. Well, on this very momentous occasion of the inaugural of the Vinayak Mission Law School's International Law Center, as well as commemorating the 75th year of the UDHR, it's a pleasure and a privilege both for me to be present here. And I congratulate, my heartiest congratulations to the Vinayak Mission Law School, its dean, and the faculty members. So I would be speaking upon, a topic which is not really the topic which I usually deal with, which is environmental law. Today is also coincidentally the International Day for Elimination of Violence Against Women, right? So it struck me that this aspect could, I could take the help of this to really highlight some of the crucial areas that have come up, in context of women-related issues. When we look at the kind of progression of the human rights of women, you would see that, yes, in the aftermath of the Second World War and the atrocities that were there, the United Nations came up, and there were several important articles within the Charter which were indicative of equal rights for women and men, as well as an affirmation of gender equality, primarily through articles, the preamble itself, Article 1, Article 13, 55, and of course, as students of international law, we could, digress into these articles in a detailed manner. It was followed up with the UDHR, the Universal Declaration of Human Rights, which is a pivotal treaty for human rights, a foundational treaty for the human rights formulations that came up later. So this milestone document, of which Eleanor Roosevelt was the chairperson, and Dr. Nabila gave earlier a very important quote by her in that context as to human rights, how we find their pervasive violations in everyday life, and especially in connection with women. So here we would find that there were some the discriminations which were based on sex, on color, race, language. There was an expansion of some more grounds on which discrimination could not be conducted. Further, you find Article 2 is very pertinent, and it has to be kept in mind, which applies, in fact, the Ms. Hansa Mehta, who was the Indian representative to the UDHR, and at the same time, we were also juggling with our own constitution. And she made a very crucial difference in terms of the vocabulary, and all human beings have equal rights. This was the kind of phrase that was intervened in instead of all men. So that was, so we find that there are these kind of pointers which are indicative of the gender equality propositions at a very early juncture. One important theme which I would like to spend a little more time on is about the whole universality of human rights vis-a-vis the cultural relativist propositions, because this has come up incessantly in various propositions, in counters, as to whether universal human rights is something which can be adopted across jurisdictions and nations. There have been critiques of this universal, the application of human rights, and essentially they have in terms of the universal, the Western imposition of the notions of human rights, the individual rights concept vis-a-vis the communal rights that the Asian societies have been more familiar with. There has been also the criticism that can we have a single document to represent diverse experiences across space and across time. So this kind of Western biased documents are alleged to have been a kind of imposition, and this can be, of course, there are so many critical insights to this whole issue, but there are some very important and significant counters to it. And one of them is that this document, Universal Declaration of Human Rights, itself was represented, was, the kind of team that was involved. It involved nations from China, Lebanon, India, Pakistan. So it was a very well represented set of people who were involved in this intricate exercise. And there were, of course, 48 approvals to it with no dissensions. Saudi Arabia did dissent on two grounds of religious freedom as well as consent to marriage, which was not in accordance with the religious tenets which it followed. So apart from this, there was not too much of, too many oppositions to it. So all cultures, when we are talking about all cultures, they are again composed of individuals. And individuals, certainly, they have the whole composition of human rights. They pertain to individuals. And cultures themselves are not static. They do adapt themselves to various changes, and a point of time where they are not very receptive to certain human rights, there may be a subsequent point of time when there is a change. So all these factors really came up, we can have a surmise and a kind of conclusion that the language of human rights is the basic universal available vernacular which really upholds the women's rights against oppression, against subjugation, in terms of the patriarchal as well as stereotypical, the versions that are there in various cultures. Beyond that, there is a very important saying by Anthony Langlois. He has called universal rights a common discourse through which cultural narratives are negotiated. So this is a very apt summation on this issue of the universal versus the cultural relativist argument. When we talk of women's rights beyond the UDHR, there have been a spate of so many treaties, conventions that have come up, and they are distinctive in the sense that there have been always the provisions of non-discrimination in terms of women for the purpose of really having a seamless operationalization of human rights, whether it's ICCPR, ICSCR, as well as the final Magna Carta of human rights in terms for the purpose of women, which is CEDAW. So CEDAW is a milestone, again, a blueprint document, which has extensively gone into various detailed provisions of human rights, how they are to accrue to women. And here, the definition of discrimination is very relevant. And what is also important to notice that this definition, which is there in Article 1, it is something which is which now embodies also violence against women. That is also a form of discrimination that has come up through the further general recommendations 19 and 35 of the convention. So if we just read it, Article 1, for the purpose of the present convention, the term discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms, and so on. So this Article 1 is really at the heart of the entire CEDAW, Article 1 as well as 2. And of course, all the human rights instruments we find, they are subject to so many reservations by the state. That is a natural corollary, as we find, in order to encourage the participation of states and to maximize the numbers of states that are active parties to various human rights conventions. But Article 1 and 2 particularly, they cannot be encroached upon because the patent substance is really contained in this. And it is very clear through the Vienna Convention on the Law of Treaties that reservations should not be against the basic purpose of the convention. So violence against women, of course, it connotes a huge spectrum of issues, and it has already been covered in terms of the Vishakha case, where sexual harassment at workplace was, it was codified into law at a later point of time in 2013. But prior to that, there was the Supreme Court intervention, which gave cognizance to the international law in terms of CEDAW and placed it principally as the main source of law for its very stringent, the kind of strictures that came up under the Vishakha case. There is, of course, the violence against women itself, the statutory enactment that has come up in 2005, and how it covers various elements of violence, including physical, mental, emotional, psychological. So it's again something which has to be then supplemented with IPC, the Indian Penal Codes, and a whole spectrum of other laws that are there. I also would like to draw your attention to one particular clause in Article 2, which talks about to take all appropriate measures. So state parties condemn discrimination against women in all its forms agree to pursue by all appropriate means and without delay a policy of eliminating discrimination against women. And there are clauses A to G that are mentioned here. This is clause F, and this is what I'd like to speak a little more. This is to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices which constitute discrimination against women. So you would find a parallel to this in terms of the fundamental duties that we have in the Indian Constitution, which is really given in Article 51A. And this is pronounced in Clause E, which talks about, this is Clause E, which talks about to renounce practices derogatory to the dignity of women. So this kind of a parallel exists in the CEDAW, as well as the domestic, the constitutional law. And this is a very important, it has a lot of significant connotation, because it really devolves a duty upon every citizen to denounce practices which are derogatory to women. So apart from the fundamental rights which are contained specifically in Article 14, 15, 16, and there's a whole paraphernalia to the constitutional content on, the women's rights, constitutionally speaking as well as statutorily, there is the inevitable duty and obligation on citizens too, right, to renounce derogatory practices. Now, when we are talking about the CEDAW, there are usually three words, which really come up in the context of human rights instruments that are to be understood a little more, in detail. So there's an obligation to respect, an obligation to protect, and an obligation to fulfill, as we usually say. So obligation to respect, it means the states must refrain from interfering with or, curtailing the rights, the enjoyment of human rights. And in this context, we are talking about women's human rights. The obligation to protect requires the state to protect the human rights abuses by third parties, and obligation to fulfill means that the state must take certain affirmative measures in order to enhance the human rights, especially of women. Again, we would look at Article 4, Clause 1 of the CEDAW, which talks about temporary special measures which can be taken up for women. So these temporary special measures, which are in the nature of affirmative measures, they are, say, pointers to a situation like India has recently adopted the 33% reservation for women in parliament and in state legislative assemblies, right? So there is this very significant kind of change that has come about in the Indian scenario. And this 33% has entailed a change in the constitutional provisions. And of course, it is subject to certain conditions, that it is on a rotational basis. It shall be taken up after the delimitation exercise and after the census, which takes place next in probably 2027 and thereabouts. So it is yet a distant dream, although not so distant any longer, which we were all awaiting this development. But this kind of a change that has come about is very pertinent to decision-making, the avenues that women must really have in order to make their voice felt over the impacts that may come about internationally and nationally. So, of course, when we talk about international treaties, The first point of response is internally. Jurisdictionally, it is the domestic legislation that has to respond first. And there is the need of the associated legislations as well as the judicial interpretations, which progressively have fortified the position of women in the Indian context. But beyond this, of course, we have certain optional protocols in human rights, the treaties, to which we have not yet, in the context of CEDAW, we have not yet ratified those, but they give an opportunity for amplifying the complaints in regards to the violation of human rights domestically, and this is an avenue which needs to be taken up more robustly. Now, the position of women, we find, has been, it depreciates considerably during times of exigencies. And this is especially felt in times of armed conflict, as well as the climate crisis, which is facing, the world globally, internationally, across the present point of time. Armed conflict has been the international tribunals in the context of Rwanda and Yugoslavia have time and again, they have echoed a very important aspect that especially rape in times of conflict, in times of, in matters of armed conflict, it would be viewed as absolutely the international, it's a violation of human rights and has to be taken up seriously. Climate crisis, and especially in the present day context when we view Ukraine war as well as the war which is the disruption that has occurred in the Middle East, that the women are specially prone and they are extremely vulnerable in such situations. In the climate crisis context, women again disproportionately bear the kind of risks which come up with such issues. In fact, when we talk about violence against women, it has been said that the climate-induced migration and even the refugee crisis, as well as the kind of the problem of statelessness, it has the complexion of a violence against women. It can be supposed, it can be approximated that it is violence against women that has come about. And again, the international community has to take it up in the manner it is needed. Appropriate measures which have been mentioned in CEDAW as well as in the Indian context, the Supreme Court has innovatively and very ingeniously expanded its jurisdiction to include compensation. This is another element which reparation or compensation has to be kept in mind for the purpose of really rectifying the kind of damages that have been incurred. So when you're talking about the issues, the miscellaneous category of issues or the kind of compounding of issues that face the problems by women today, it is the social, economic, political inequalities, and you would find that gender inequality is a key driver of poverty. And in fact, you would see that education for women is a primary input, and targeting women and children for education, health, and employment is a very important policy formulation. It has been found in earlier research that an increase of 10% in female participation in schools results in 3% approximate increase in GDP. So this is a research study of the year 2012-13. This needs to be updated and to be seen as to whether such similar studies have been conducted in the recent past. Violence against women has now, it has new formulations. It has acquired new connotations in terms of cyber crimes, in terms of the digitalization and the cyber stalking, harassment, etc., that has now become part of criminal, the Amendment Act also to some extent, but there are certain species of crime that still remain non-monitored. We must understand that states are not the only actors. CIDOR is, of course, it's very important to know that CIDOR covers both state actors and non-state actors. And the non-state actors have really increased over a period of time. So you would find that apart from individuals, when we talk about domestic violence and so, we also have corporates. We have transnational, multinational corporates, and there are crimes again where, there are violence against women again, as well as issues pertaining to the gender equality in terms of wages, in terms of remuneration, in terms of recruitment of women itself. So there is a spate and a host of such non-state issues which also have to be borne in mind. International human rights law is not, again, the only normative order. There are others, especially as the non-legal orders, as customary, religious, cultural norms, which ultimately have to be reconciled with the universal precepts and principles that we are so familiar with. So in the ultimate analysis, there is the need for really bringing together the diverse national and international experiences that we've had so far in the context of women's human rights, and to advance, over the existing, say, the kind of the legislative frameworks, the legal frameworks, and to practicalize on the issue of women rights, where we involve the civil society in terms of the NGOs, the women human rights defenders, and we can have all stakeholders with the state and the women themselves and all entities that can come together for this purpose. So I would like to thank again the organizers for this very, very significant occasion, and to give the opportunity to me to, just expound my views. Thank you again. Thank you.
Well, this occasion reminds me of my professor sharing a paper during my UG days, and it was titled as, "Is Law Male? Let Me Count the Ways." And he stressed upon rereading, unreading patriarchy from legal drafting, jurisprudence, and literature. And sadly, yesterday, we lost the first women CJI of India, Justice Fatima Bibi. And this brings us to wonder that though today we have Supreme Court working on full capacity of 34, yet there are 3 women judges. Is gender parity or diversity rather a distant dream? Thank you, Professor Bharti. Now, I would like to introduce our third speaker, Dr. Archana Negi. Dr. Negi has been a part of the Center faculty since April 2004 at JNU. She holds a master's degree in political science from the University of Delhi and a PhD degree in international law from Jawaharlal Nehru University. Her thesis dealt with the interface between environmental issues and international trade rules as embodied under World Trade Organization. She has been contributing to the teaching program at CIPOD since 2002, offering MPhil courses in international organization. Dr. Negi currently teaches 2 MPhil courses, International Economic and Financial Organizations and International Regional Organizations. Outside of JNU, Dr. Negi lectures at various institutions such as Indian Institute of Foreign Trade, IIFT, the Indian Society of International Law, ISIL, the Indian Law Institute, ILI, the Worldwide Fund for Nature, India, WWF. She has presented various academic papers in several seminars and conferences. Over to you, Professor Negi.
Um, Thank you, Professor Nabila, for the generous, embarrassing introduction. It's very, very nice to be here. I'm really particularly glad to be in Chennai. Thank you, Dean Anand, for having us here, and all of the faculty for warmly welcoming us. This is also a great opportunity for us because I get to meet some of my colleagues from Delhi here in Chennai. So I have to come all the way here to meet them as well. But most of all, I'm very happy to meet the students. We don't get many opportunities to be able to speak directly and share with a captive audience with doors locked what we want to say, right? And you don't have a choice, you have to be here. So I seek your indulgence for a little bit more time. Allow me to share with you what I've been thinking. I mean, there's a lot to be said. A lot has been said about international law, about gender, etc. Professor Shambhavi told me that we are also here commemorating or seeking to commemorate the UDHR, the Universal Declaration of Human Rights. So I thought let's stop and think about it a little bit. If you go to the website of the UN High Commissioner for Human Rights, the Office of the High Commissioner in Human Rights, they have the Human Rights 75 initiative, and they have a ticking clock on it, which is showing you the days. So if you open it today, you will find the number 15 there, which tells you the number of days we are away from the official Human Rights Day, which is 10th December, where 75 years of the adoption of the Universal Declaration on Human Rights will complete. So anniversaries are always opportune times for reminiscing, and the method I chose for today, therefore, is legal history. Often when we teach international law, international organization, you must have heard this many times, that the moment of conception is important. It is important to go back to the historical reality when this particular idea was conceptualized, whether it is an international law or an international organization. Otherwise, you probably can't explain many of the things that these legal documents contain or these organizational structures, etc., reflect. So stepping back in history, maybe revisiting the UDHR and the conferences that were happening then, what was happening at that time is important, and I'll try to draw out one or two of the important narratives that were quite visible when the UDHR was being formulated. I will, of course, link it back to my pet area in international law, and since there are many on my team who teach environment, I'm sure they will agree that it's all about the environment, right? So we can't not talk about the environment, so I'll try to link it and come back to the environmental part of linking human rights with environment. So the history of the UDHR, if you, I do have some pictures, if they can run maybe. Great, so you already see the text there of the UDHR, the commemorative poster that I talked about. This is the 1940s, after the end of the world wars and the Holocaust, and the basic never again sentiment which drove the writing of the UDHR, basically to say that the UN Charter, on the one hand you're setting up this organization, the UN Charter, but that should be supplemented with or complemented by a declaration which will bring together the norms, right? And this was mentioned by Dean Anand as well, that you have a set of norms that the world aspires to, right, look up to. And this was the document which was taken up in the very first session of the UN General Assembly when it met in 1946. The GA reviewed the draft and then sent it to the ECOSOC. There was a drafting committee, etc. And the team was led by Eleanor Roosevelt. Professor Bharti has made my task easier. She's already mentioned to you some parts of the role that was played by the person who led the formulation of the Universal Declaration on Human Rights. But just to say that the drafting committee of the Universal Declaration was a very interesting one. The composition included diplomats, philosophers, academics, judges, jurists, of course, but also playwrights and also trade union leaders. So there were a lot of points of view that were coming in when the formulation was being done. There was a World War I veteran, there were international lawyers, of course, and so it was a very interesting grouping. And many different countries too were represented in the drafting committee. Importantly though, it is interesting to note that the committee was headed by a woman, which at that time we couldn't really take for granted. Right? So there are two themes or two seminal contributions to the drafting of the UDHR that are quite remarkable, that I want to talk about, and a lot has been written about them. If you are interested in history, you will also find it on the UN websites. There is a lot of chronicling, recording, photographs, etc. of what was happening then in the 1940s. Now, the first contribution, of course, is what you mentioned, the contribution of women delegates to the formulation of the Universal Declaration on Human Rights. So, Eleanor Roosevelt's leading role as chairperson of the drafting committee of the UDHR is, of course, very well documented. And one of the seminal roles that she played, because remember this is the 1940s, and this document is being drawn up in the midst of the East-West tensions of the time. And it is usually attributed to her personality and her personal strengths that she was able to bring together these two different viewings and put them together into this Charter of Human Rights. So she had a leading role to play as far as that was concerned. Hansa Mehta has already been mentioned, the woman delegate from India, who insisted that instead of all men are born free, all human beings are born free, is what should be used. And this has actually been put in Article 1 of the UDHR. And there was resistance. Interestingly, there was resistance to her proposal that this should be the case. Then there was Minerva Bernardino. Let me show you the faces of some of these. So these are some of the drafting committee members. You can already see the countries that they represent. So it's very interesting because you have somebody from China who's basically talking to the drafting committee and telling them it's not all about Aquinas. You should go to Confucius as well. So there are other ways of thinking, etc. So those discussions did take place, and this is being the 1940s, it was interesting. And these are more or less the 9 members that you see. Again, photographs all credited to the UN website, which has, and it's stuck now. There. Here you can already see the session where the drafting was taking place, but this, yes, my favorite slide, where you see a lot of women who actually contribute to the drafting and formulation of, so one of these, I haven't labeled them independently, but Minerva Bernardino, for example, from the Dominican Republic, argues for the inclusion of the phrase equality of men and women in the preamble of the UDHR. Begum Shaista Ikramullah, you can see her there, from Pakistan, advocated for the emphasis on freedom, equality, and choice in the declaration, and also championed for the inclusion of Article 16, which is to do with equal rights in marriage, which is very important, of course, also from the context of Asia. Then there was Bodil Bechstrup from Denmark, who replaced all or everyone, the words all or everyone, wherever the words all men was used, to make it sort of gender neutral. So if you read the UDHR, it's fairly progressive in that sense. The delegate from France, who advocated for a mention of non-discrimination based on sex to be included in Article 2. So this has been included as well on the insistence of some of the women delegates. And lastly, of course, also Lakshmi Menon from India. And you can see her picture right at the bottom corner, who argued for the repetition of non-discrimination based on sex throughout the UDHR, as also the mention of equal rights of men and women. So needless to say, the women delegates played a very important role in formulating the UDHR, and it's important to remember this as we stand here to commemorate the UDHR and also to launch the CPIL. And Dean Anand, I'm very happy to see that there are a lot of bright young women here. I would say 50%, touching 50% at least. So I would also like to add my personal agenda on this, requesting you that hopefully Promoting international law is also done in a gender balanced way. This is not always the case in parts of India, even the parts that, that we've seen closely. So I'm very happy, those of you who are here, this is your inspiration story that women have in fact played a very important role in the making of international law in very, very seminal ways. So that's one. The second story which you find very often recorded, chronicled and told is of course the role that the Indian delegation played in formulating several provisions of the UDHR. And again, this is an interesting story because we are talking about India's pre-independence engagements with international law and international organizations. So India did have, for example, a delegation to the Bretton Woods Conference where the World Bank and the IMF were conceived. It also had a delegation in San Francisco where the UN Charter was finally signed. And the Indian delegates had a very, very strong presence in almost all of these negotiations, which interestingly are prior to the emergence of India as a full-fledged sort of independent state. And of course, there is a legal aspect to it, which we can discuss later maybe. So Milun Kothari has written about this. And he wrote about it 5 years ago when the 70th anniversary of the UDHR was being celebrated, and his work and research has been reprinted at several places. And he, of course, talks about all of the contributions that the Indian delegates made, some of which are as follows. So the first one is to do with the women's rights, which we've already discussed, Hansa Mehta, etc., and their contributions. Yeah, there you see a picture of Hansa Mehta with Eleanor Roosevelt. Of course, Vijay Lakshmi Pandit, I will come to that. A second issue area of the UDHR where India has a very important contribution is the whole idea of non-discrimination, where the words color and political opinion were added in that whole list of characteristics in the non-discrimination provision. A third was to do with freedom of movement within countries, Article 13. This article was also suggested and included at the insistence, of the Indian delegate. In the right to work article, Article 23(1), the words just and favorable conditions of work were again contributed by the Indian delegation. And of course, the ideas generally of secularism, multiculturalism, cosmopolitanism, etc., universality of human rights were the themes advocated by the Indian delegates. Now, an interesting parallel has been acknowledged between the timing of the drawing up of the UDHR, which is 1948 and just before that, and India's deliberation of its new constitution, which was happening at exactly the same time. So Kothari makes this interesting argument also that a lot of the learning that the Indian delegates had from the freedom movement in India and also the discussions around the Indian constitution also fed into the sort of parallel ideas that were being discussed at the UDHR. So in that sense, the reflection that the Indian delegates could bring to the drafting, or the imprint that they could bring, is something that is interesting. In fact, he goes even further to argue that, and I quote from his piece, which he wrote 5 years ago, he says, quote, "This coming together, this coalescing of ideas and visions between India and the UN was not a coincidence, but a well-planned strategy employed by Jawaharlal Nehru under the guidance of Mahatma Gandhi." Now, of course, you can go into the research and see whether, how much of this you agree with or whether you see merit in this, etc. But certainly you can see that the imprint that comes from the Indian delegation is something interesting to note. So you have Vijay Lakshmi Pandit, I had her picture there as well, at the San Francisco conference, basically, outlining the positions that Nehru and Gandhi took in their speeches, in their political positions, where they wanted a new organization to champion, the concept of emancipation of all oppressed people. So the colonial experience, therefore, also reflects very closely into this building up of a universal declaration on human rights. So let me stop there as far as those two contributions are concerned and just speak very briefly about the UDHR. So the UDHR took less than 2 years to compose. Given the time, it was quite interesting that a lot of the differences could be papered down very, very quickly, and there was a broad formulation on which there was consensus with no dissents. There were some abstentions, but no dissents. And the UDHR has often been referred to in, well, of course, poetic terms as the common language of humanity, the international Magna Carta, the conscience of the world, and also a milestone document in the history of human rights. So for the first time, you have this document setting out the fundamental human rights to be universally protected. I'm sure all of you read the document. If you haven't, please have a quick look at it. You will find 30 articles there spreading over both types of human rights that we today are very familiar with, the civil and political rights, as well as the economic, social, and cultural rights. Of course, it took some time before the two types of rights were then consolidated into legally binding treaties, the two covenants, the ICCPR and the ICESCR. What is important to see is that the UDHR, in a sense, is also contributory because it is a living document, because it instigated or it initiated a whole lot of action in specific areas of human rights protections. So a whole lot of treaties, you mentioned the CEDAW, for example, but also the others, the CRC, and a range of what we call the core treaties, I'm sure you're familiar with them, were subsequently adopted, ratified, etc., the starting point being the UDHR. So the catalytic sort of force of this document, which is beyond just, a lot of students in class ask, well, if it is soft law, if it is not binding, what is it really about, right? So we have to see it also in that larger framework of what it managed to then lead to. Now, let me skip some of this because I don't want to take longer than I have to. But the UDHR spoke about a certain set of rights. It could not, of course, deal with all sorts of issues which subsequently emerged. And a large part of the discussion, so I'm skipping actually the part about civil political rights or economic, social, cultural rights, and coming to what are called or referred to as the third generation rights, right? The solidarity rights, right to development, right to peace, right to environment. Are these really rights or not? Right? So one of the core questions which comes up in a human rights environment class is there a right to environment? And constitutionally, if you do a comparative of constitutional laws across the world, you do find it very, very strongly appearing in some constitutions and missing altogether in others, right? In India, I hope you're familiar. Anybody? Students? Where should we go to find the environment in? So 48A is where you will go. For 51 AG is where you will go. There you will find directive principles and fundamental duties, but not really fundamental rights. And for the fundamental right, you will not find the word environment. So if you're lazy and if you control F, a soft copy of the Constitution, you may not find it. But it is very much there. So please take heart. It's in Article 21 and it's been read into it by the courts. And Professor Ranjan earlier very eloquently explained to you a whole lot about how the courts have worked. So environmental protection has been, of course, read into Article 21, which is the right to life as far as. But that is at the national level. What about the interface at the international level? Now, environment and human rights, and now I'm really fast forwarding to some of the current developments. In the current times, there is an increasing focus on this interface between human rights and the environment. That we need to basically settle this whole debate about what this interface or this relationship should look like. And there are 2 or 3 focus areas or fora where this interface is being discussed and developed. One is, of course, the Human Rights Council itself. The UN Human Rights Council has increasingly started looking at aspects of environment and treating them as issues of human rights. So there is a set of resolutions which you can look at. They are there on the UNHRC website, where they have looked at resolutions which look at certain types of environmental harm or certain types of vulnerable groups that get exposed to environmental harm. And 2021, you have a resolution which actually talks about the right to a clean environment. So the interface in that sense has become stronger because there have been special rapporteurs who've been mandated with developing this interface, etc. The other big sort of victory of sorts is in the forum of the UN General Assembly itself. So last year in 2022, the UN General Assembly adopted the resolution which really brings together environment and human rights and talks about a right to a clean environment. Now you could ask further than this that what is the legal standing of a UN General Assembly resolution, right? And especially vis-a-vis an SC resolution. And for that, the legal experts are here and they can talk more about this. But even the UNGA resolution was a big victory in terms of bringing together environment in the context of human rights. The last thing that I want to mention is what is happening in terms of developments in the realm of climate change. Climate change has become one of the very, very core issue areas where the procedures that are being used to address issues of climate change work through the processes of human rights. And there is a fascinating categorization of all the climate litigation that you now have across the world emerging, one set of which works through human rights, right? So whether it's a case in Pakistan where a group of women in the village say that our human rights are violated because our sources, water sources, are getting impacted by climate change. Or whether it's a group of very rich women in Switzerland who are above 65, who say we are very old, we have health issues, and climate change has a specific impact on us, we are vulnerable, and they went to the court with that. So one is through climate change impacting the human rights of human beings. The other very interesting development has been attributing human rights to elements of nature itself, which is very fascinating, right? Does a river have a right? The Uttarakhand High Court thinks it does. I think it was not accepted at the higher stages, but the High Court did hold that there was a right to life that the river had. So there is I can't go into it, but there is an ocean or a tsunami, if you would like a better comparison, of climate litigation which is happening. Also at the international level. So these cases are mostly in the domestic space. At the international level, there are some very interesting advisory opinions recently. One by the ITLOS, which is the International Tribunal on the Law of the Seas, and the other in the American court. What is the American Court of Human Rights. Now, these are advisory opinions which directly ask questions linking environment and human rights. And the question now also has found a landing space in the ICJ itself, right? An advisory opinion of the ICJ on what climate would mean in terms of rights, who would be the duty holders, how could you hold states accountable for issues of climate change. So all I want to say by introducing this sort of issue area is that this is a very fertile space. There is a lot happening. There is a lot that is going to happen in the context of bringing together the question of rights and the question of environmental protection, and specifically that of climate change. Of course, the structural challenges remain. How do you talk about something as a human right unless you can very categorically break it down into specific targets, unless you can have a particular duty holder, vis-a-vis the right? All of those remain. So please keep a lookout for how the court deals with it and what comes out of it as far as that is concerned. So let me go back then to the UDHR, which is where we started. You will see it's had a long journey. It started with a certain set of rights which were important in a certain historical context, but a lot that has grown over these 75 years links back to the core idea of human rights protections which the UDHR put forth.
So let me stop here with that. Thank you so much. Thank you, Professor Negi. I guess we were successful in gluing some of the most important and pertinent themes of international law during our sessions. And this brings us to one of the most exciting segments of our program, that is the Q&A session. I would like the audience to raise their hands for asking a question, and they can also reflect if the question is directed to a particular speaker or it is to be answered generally. Oh, even before I could conclude, we had a raise of hand. That's really nice, yeah. So I think we have a first question from Professor Nishant. If we could pass the mic.
So I think, good afternoon, everyone. And first of all, thank you so much to the panel members for their presentations. I have two questions. One with respect to, let's say when we talk about India and the recent stance of India on certain issues. For example, if we talk about judiciary, the right to marriage, India seems to take a diplomatic stance on certain issues. And if we talk about, for example, diplomacy, right? India tend to, let's say, shift towards an approach which is again diplomatic, and we do not tend to, for example, go towards using international law jargons, right? So, again, it's a question open to the panel, and I would go back to my notes as well when I was making my notes, right? So, if we talk about, in a world where diplomacy often speaks the language of international law, do you think India is missing the lawfare trend, and should it consider sending its diplomats to an international law vocabulary boot camp to spice it up? That is one question. And the second question is with respect to UDHR. The prominence it was supposed to gain, it may or may not have gained in last 75 years. If we look to the future and the coming 25 years, and the kind of emerging issues which are coming up. For example, the energy shift or the energy transition, or we talk about technological advancements and the privacy issues which comes along with it, right? Do you think there is a need to introduce new rights into it, or should we take, let's say, innovative approaches to tackle it? Thank you so much.
Yeah, thank you for the question. I think on the issue of, to what extent India has been able to mainstream international law vocabulary in conduct of its diplomacy. I think, frankly speaking, India has not been able to do a very good job, especially if you compare with what Western powers, say what US has been able to do. The only sort of bright example recently was that, during the India-Canada row recently, the diplomatic row, for the first time I saw a MEA press release quoting specifically the article of Vienna Convention on Diplomatic Relations, which usually has not been the case. So I have argued for this, and others have also argued for this, that India has to use international law vocabulary in conduct of its diplomacy. And the reason for this is because when you cite international law, just like US does, which perhaps has a track record of violating international law more than implementing it, but all its violations are also justified on some legal principle, right? So that gives legitimacy to your action. And therefore, international law has to be mainstreamed. Now, this will require more than sending diplomats to international law boot camp. This would require more a structural change. So if we look at the MEA, for example, we have the Legal and Treaties Division in the MEA. But this Legal and Treaties Division is understaffed. They're just about maybe 15, 16 people handling a gamut of international law issues across different ministries. And it's really difficult to expect 15, 16 people to, sort of do a good job. So it needs to be staffed. It needs to be staffed with more expert lawyers. And there also has to be a greater engagement with the academic community. I can, for example, since I work on trade law as well, I can say that when it comes to matters of trade law, etc., we see the Commerce Ministry, engaging with academics, at least relatively better than what the MEA, for example, does. So even, there's also a difference in terms of how different ministries take up their job. And we don't find any consistent pattern. So there has to be a greater engagement with the academic community. That, I think, can also play a role in mainstreaming international law in the conduct of our diplomacy.
No, I completely agree with this, because one of the big gaps we have is this huge sort of chasm between the academics and the practicing diplomats who are out there. And one has had a lot of occasions where you feel this sense of gap, because what the academics do is sitting on the bookshelves, being read by the students, hopefully, but otherwise gathering dust, not really reaching inputs. And, diplomacy also needs a sense of constancy. So one example, specific example that I want to give is, for example, in ozone diplomacy, which is very specific, very technical. I had a chance to interview somebody at the ozone cell. And when I say somebody, it was only that one buddy who was running the ozone cell. And what he was doing was that every time the diplomats keep getting posted in and out, and every time they start from ground zero, what is ozone, what is O3, the American delegation, on the other hand, has a gentleman who's been there right from the inception of the Vienna Convention, through Montreal Protocol, through each of the amendments, adjustments, etc. So there is this sense of, constancy also in their diplomacy. So I think a lot of matching up needs to be done in several ways as far as the diplomacy is concerned. And interestingly, some of these historical stories that exist about the contributions of India, which I've also done some research on the Bretton Woods Conference and how the Indian delegation had an impact there, that seems to have receded now, because it's not as impactful as it used to be. So, yes, you're absolutely right. Something needs to be done about it.
I think before we proceed, I would like to introduce one of our guests who is with us, Dr. Daniel Haridas, who is a retired judge. So could you just could, yeah. Thank you for being here. We are honored to have you, sir. Thank you. Thank you, sir. The next question, I think we can take up the next question. Okay, we have a question right at the back.
Good afternoon. So my name is Samudyata. I'm a faculty with VMLS, and my question is in relation to something Dr. Bharti said, but anyone on the panel is sort of free to answer it. And it's with specific regard to this sort of binary that conventions like CEDAW sets up, where it frames culture as being something that is in opposition to the rights rather than something that needs to be brought together because rights are part of culture. But my main question is, when we set up universal values as being something that is opposed to culture, and this imagination is something that even domestic law reflects to some extent, with the languages that courts use when they talk about things like constitutional morality and all of that, it becomes something that a law student going through law school kind of just by default begins to understand the society through the lens of. And I was just curious as to how in your classrooms do you perhaps help students see beyond this understanding that the culture is something that is in opposition to the law, or the law is something that has to fix culture rather than them just being parts of each other. So that was my question. I'm not sure how clear I was, but yeah, my question is about the classroom approach.
So, yeah, so that's the kind of perennial conflict that you find between the cultural norms and the universal values that have come about. So it's not easy to resolve because there are the staunch kind of arguments that would be given in favor of either. But of course, the legislations and the Supreme Court judgments they become the basic tool with which to really advance your topic in the class. So it's not subjective, it has to be within the legal framework. And the Supreme Court has, of course, in recent times come up with quite a few mind-boggling, judgments on the issue of pertaining to women especially. And it has come across all, it has breached, the personal laws. And in that sense, they could be termed, progressive in a manner, but of course, there are critiques to it also. So it is basically, you have to keep yourself within the, of course, there is a critical aspect which you would carry out in the class, and there would be, you would give the different points of view, but you keep yourself within the legal realm. So that's a basic idea. Yeah.
Thank you, ma'am. Any more? Yeah. Bunch of questions. Yes. So I think we'll go with Professor Spurti first, and then we can have Professor.
Thank you, Nabila. My question is to Bharati ma'am. Ma'am, when you were speaking about the actors of SIDA, you were mentioning the practices of the customary and religious practices which had to be rebuilt so that in order to make gender equal basis. So how are we going to do that with Indian society, ma'am? Like looking at the present scenario, we don't have much of activism coming through public litigation or as a group litigation. It is more concentrated towards individual based. So, and also this is something that is different from each society. Like again, universality concept of principle doesn't apply here. So my question is, how are we going to rebuild when we are facing this issue with respect to Indian society?
It's a kind of voicing of the concern which you have said in classrooms and coming out in the open, and through the activist measures, or how do we really give a voice to the women. So here, although we do not have that kind of public interest litigation exercise, but we've seen that the Supreme Court again has taken upon itself, to really espouse the cause in that sense. And earlier it was that, fundamental rights as the touchstone of all laws. This was kind of precluded from the sphere of personal laws. And it has now been recast. It has been now, in a way where there is a total reorientation of the Supreme Court's through the judgments in various cases, and you find, whether it's talking about the triple talaq case, and then you have the union coming up. The parliament has come up with the laws, the statutory enactment. So there is a kind of sequencing that is building up, that yes, there is the formal first part, which is the judgment, and then it is followed up in some way, to give a more rigor to the law. So it is slightly not so internalized as yet. It is yet, the institutional structures that are giving a greater vent on this issue.
Thank you, ma'am.
Thank you, Professor.
Can I take a second?
Yeah, absolutely.
To add, because I think these are very interesting, very, very perceptive questions, because we deal with this, grapple with this all the time when we talk about human rights, because human rights has always been constructed within this binary of whether it is universal or specific culturally, etc. And one of the helpful techniques also, to add to what Professor Bharti said, is to go down to the root. And the root is essentially human dignity. And while there may be differences about the nature of how you view that dignity in different cultures, the core idea is that we respect and protect human dignity wherever it is, right? So sometimes it works more usefully not to look at the rights themselves, and not to look at whether, right to education or right to food, which are specific rights, but to also look at processes. Non-discrimination is very useful. right? It helps you overcome cultural relativism to some extent, because then you are focusing on the principle, the idea that whatever is being offered is offered in a non-discrimination based way to everybody. Transparency, accountability, all the good governance principles help to kind of deal with this distinction. But I think the core, again, coming back to the concept of human dignity, which is really the core of the human rights, the Bill of Human Rights, as well as all the other core human rights treaties. So, yeah, but we have to work around it. It is a problem sometimes.
Thank you, Professor.
Okay, so I have a direct question to Dr. Ranjan. While you were talking about monoism and dualism, do you also think that there is a specific pattern that the Supreme Court has been following while they say that, the monoistic approach, like the judgments that you sort of pointed out, and for the dualist nature of judgments? So is there a specific strategy, or do you see a pattern in which these two are parallelly being followed?
Yeah, so if you look at all the cases where the Supreme Court dealt with human rights, for example, you will find a greater sort of movement towards monist incorporation of international human rights, UDHR and several other covenants which were cited in the Vishakha judgment and also in the Puttaswamy judgment. And likewise, if you look at instances where the court dealt with international trade law, international investment law, international taxation, there you will find a greater sort of emphasis on the dualist tradition. But this is not always true. For example, if you look at the same-sex marriage judgment, the judgment could have been that there is a fundamental right to marry, relying on UDHR and relying on several international law instruments, but the court did not go down that route. So there is an exception to that. Likewise, the Salimullah judgment, which I discussed, where the court could have said that non-refoulement is part of customary international law and therefore binding on India, even if India has not signed the Refugee Convention. That case again did not go down that route. So within this broad theme, which I said, that I also find that there are aberrations, and in all those aberrations, the instances were politically sensitive. So maybe the court wants to play safe in those instances. And doesn't cite international law because that might not help them in deciding whatever. But the other problem that I have with this classification is doctrinal. Wherever the Supreme Court says, Supreme Court follows the dualist tradition when it comes to, say, a matter of taxation, the Supreme Court then has to say that we are following a dualist tradition because this is not a human rights issue or something of that sort. Now, the Supreme Court doesn't say that at all in these decisions, and therefore, as a student of international law, I'm left confused that what is the basis to say that when it comes to sexual harassment you will implement international law, and when it comes to taxation you will not. Because if you look at international law, it does not create any such hierarchy of norms. The only hierarchy is in the form of jus cogens norms and other norms, right? But there is no such hierarchy in terms of, say, one treaty over the other or one customary norm over the other. So there I think that the Supreme Court is not very robust in dealing with international law. One would expect a greater degree of sort of more critical engagement than merely referring to international law casually.
I guess our dean has a question. Yeah, student questions. We have one. Yeah, Professor.
Sir, again the question.
Okay.
Sir, again the question is to you. It's a follow-up question on the same topic. So you are saying it as dualism and monoist. Why can't we see it in the way of multilateralism for achieve equal and resilience the world? Why the principle we need to stick only to dualism and monoism? So why can't it be a multilateralism?
See, what is the doctrinal basis of dualism? The doctrinal basis is that international law always suffers from what is known as legitimacy crisis, in the sense that the manner in which international law is created, it doesn't enjoy the kind of democratic legitimacy that domestic law does. And therefore, it is thought that cannot be presumed to be applicable on the national, especially when it affects their rights, unless or until there is a parliamentary intervention in doing that. So therefore there is a strong argument that why there should be a dualist tradition and why you can't blindly accept international law as part of the domestic legal system. But on the other hand, and I'm sort of not giving a direct answer to that question because there is no easy answer. But on the other hand, there are also instances, and which we find in the last decade or so, where populist right-wing regimes are focusing on domestic law and are ignoring international law in those instances where international law can actually act as a bulwark against majoritarianism or anything, which they are doing. So there have been instances, there was this very interesting article published in the International Journal of Constitutional Law on how the Israeli Supreme Court, for example, has been following a populist approach. It is neither a monist approach nor a dualist approach, but a populist approach in interpreting domestic Israeli law, completely ignoring international law. So there can be instances where international law can actually act as a bulwark against majoritarianism. And there I agree that the spirit of multilateralism perhaps would be more befitting. But then, as I said, courts at the end of the day, we are told in the classroom that courts decide cases by applying law. While that's true, but the courts also decide cases by applying politics. It's just that they don't say that. You have to find that politics within the decision. And this is not true. I mean, you look at the decisions of Krishna Iyer, you look at the decisions of several judges, you will be able to locate the politics of the judgment as well, right? So I think that politics plays a very important role, even in what the court does.
That's a very interesting observation, Professor Prabhash. I think Professor Sarvanan Ravi, he is the faculty coordinator for a Center for Maritime Law, wishes to ask the question. Yes, sir, please.
A very good afternoon to the people who are in dais. So I have a question, whether it is possible to have a universal principle in relation to protection of environment while we have, while UNFCCC and Paris Convention advocates for CBDR principle, that is common but differentiated responsibility principle. Because I guess there can't be any universal application because it all depends upon the common but differentiated responsibility.
Well, the CBDR principle was really a victory for the global south, as it were, right? This whole emphasis on reparations or historical responsibility in environmental terms. So differentiation is very much still accepted. In fact, even with the Paris Agreement, where there was a lot of concern because the dual listing shifted and ended with a single listing where everyone now has certain emission reduction targets. But differentiation remains in the sense that the targets come in a sort of bottom-up approach where countries go and tell the UNFCCC Secretariat, this is what I plan to do and can do, etc., and you set your own targets. For sure, in the context of environment, I would say that differential responsibility is something especially countries from the south have to continue to fight for diplomatically, when I say fight for, of course, because it's all been discussed before. I mean, the contribution that you made to the problem and the capacities that you have to address them. So differentiation hasn't really gone away with the Paris framework. It is there in terms of different timelines, etc. But the process had to be changed because of that huge deadlock. There was a decade of complete deadlock in the climate negotiations. So multilateralism itself is imperiled in almost every field where it should be moving forward. Nothing is moving forward. So this was basically a sort of halfway house compromise, right? The only way it's going to work is if you tell them, ask them. That's why you had the nationally determined contributions, and then expect them to follow whatever they lay down. I think it will remain part of the climate regime at least.
Thank you, Professor. I think we can, yeah.
Good afternoon, everyone. I have a quick question. Anyone can answer because it's related to international law, environment law also. So we all speak about environment, safe, no cutting trees and so many things we say. But when it comes to international law, Right now we see more conflicts that is happening, maybe Ukraine or Israel or whatever. So we see so many buildings that has been collapsed or so many things we see in the news. My question is, we have something in Geneva Convention, protection of our heritage or culture, and we speak about women protection also. Where does the environment stands here? How do you think that international law can balance it?
Dr. Archana would be adding to this because she's the international sphere. She would be having inputs. So I believe international humanitarian law, when we look at the law of armed conflict, there are two components to it, which is of course in relation to persons and in relation to the means of how you conduct war. So it is within that component of means where there are several conventions that have come about and which really may be having that kind of dimension of having environment within its fold. So this is an area, the intersect of armed conflict and environment is something which has not been really paid attention to in that sense, where you're speaking in the current context. And it certainly deserves greater scholarship and research and so on. But it is, there is a legal framework, which is, of course, Geneva Convention, and beyond that, the chemical weapons, and there's a whole I think, assortment of laws in relation to minefields and whatnot. Yeah.
Yes, I think it's a very important question, especially given the frequency with which we are sprouting wars all over the globe, that if we are interested in environmental protection, we have to ask what wars are doing to the environment. Because what you protect in the everyday life can be one step ahead and 100 steps back, because we know what happens during wartime. Humanitarian law is still quite incapacitated as far as environmental protection is concerned. There's been a lot of talk about having a separate protocol that specifically deals with environmental protection. So far, because of the problems of, how do you implement, how do you quantify, those problems remain. There are, however, some specific laws which specifically address these situations. So one very interesting convention is something called the NMOD Convention, or the convention which prohibits environmental modification for the purposes of war. And this was negotiated, interestingly, after the Vietnam War, where the forests were being attacked in order to expose the guerrillas, because the Americans couldn't deal with guerrilla warfare. So they said, let's do away with the environment, etc. So because of that, you had a specific convention which tells you that you cannot modify the environment as a means of warfare. But other than that, environment as a victim, which would be more, within the ambit of humanitarian law, that hasn't really consolidated, or, so we still have a long way to go before that happens. Even, human beings, if I can indulge in some species narcissism, as they call it, saying that human beings are more important than other species, even human beings are not given adequate protection, right, in humanitarian law. So the environment has to wait.
I think this also brings us to the discussion where we have something about Polly Higgins coming up with the idea of ecocide as the fourth war of crime. So I think we are in a very positive wave of, developing relevant jurisprudence where we could see, the fourth war of crime, ecocide, actually taking a, proper shape altogether. So I think we can have one more question, and I think it's our dean who's been waiting for the question now.
Thank you. Yeah, because this has been a truly enriching set of conversations from each of you, and I think sitting here, looking at it from the lens of an educator, I could think of very many themes that can get students interested and invested in international law. So I'll just go back to one of the things that I had sort of raised as a concern in my welcome address, which is the issue of how do you get students trained well in international law with the kind of learner motivation required for the same. And there is a specific reason I asked that, which is that somehow there is this wedge in their minds that, this is something way too sophisticated or nuanced and more esoteric than what we see in our domestic courts and practice areas, and therefore instilling motivation sometimes can be a challenge. So what are the ways in which as educators we could contribute better to building out that blueprint for a good model of teaching and learning international law in each of your views?
Yeah, that's a very good question, and we all sort of face that problem. And it's absolutely right that if you ask any average law student, the natural attraction is towards domestic law. It's not towards international law. More than it being sophisticated, I think that most students perhaps think that they will not be able to make a career in international law. They don't see it as a means of livelihood, for example. And they see domestic law as a means of livelihood. That's one. And the second is they also feel that international law is not really law in the sense in which domestic law is. The second question can be tackled more easily in the sense that whenever a student asks me, oh, as I said, there's so much of violation of international law, so is it really law? I said, there's so much of violation of domestic law as well. You have governors behaving in a crazy fashion. I'm speaking this here. So you have, domestic law is also being flouted left, right, and center. But that does not mean that we stop taking domestic law seriously. So then why do we stop taking international law seriously? On the first question that whether you can actually make a career in international law, I say that yes, there are instances where people have made flourishing careers in international law. I mean, it's said about Jan Brownlee that, when he went to address in some conference and he was said that, does international law exist? He said, look at the Bentley parked outside. So international law exists. So that is what has given me that kind of income and fame. So there are examples, and I think to popularize international law, it might be a useful thing that you can do as strategy is to, invite people who have made a name for themselves in international law, academics, practitioners, international judges, etc. Our law schools generally tend to focus too much on domestic law, which we should do. I mean, I'm not saying that you don't invite, retired judges, etc. But you also invite people who have made a name in other fields. So, because when students interact with them, see them, then they feel inspired. And that could be one part of strategy. It will not give you results overnight, but it can definitely give you results over the long run. And the second thing that I think should be done is to have more elective courses on international law. This is something which I suffered when I did my law from Delhi University. We just had one compulsory course on international law and there were no electives on international law. So all my international law learning was when I did my LLM and PhD, etc. But now I see in law schools, for example, say at NLU Delhi or at several other law schools, there are elective courses on international law. And you will find people getting interested in humanitarian law because there is something that they can relate. So today, even those who are not interested in humanitarian law, you will hear, Rajdeep Sardesai coming on television at 9 p.m. and talking of international humanitarian law. So because there is a context to it, right? So there are ways in which you can, motivate students to relate to it. But you need more good role models, who can motivate students on this. Yeah.
Thank you.
So beyond the learning component, because that's been emphasized by Professor Prabhash, I think, say in terms of activities also, say whether it's moot court activities or say essay writing or some kind of invitation to the students generally in the law college or even beyond. So you can have the national level competitions which could attract, a lot of upcoming graduates, for taking part in it. And then beyond this, the formal structural subject, I also feel that every branch of law has an international dimension to it. So, whether you're talking about private international law, you're talking about public international law. So, faculties can be actively encouraged to, to really indulge in it, to elaborate on it, elucidate on it, so that, the whole subject of international law becomes more invigorating and more intensive and more interesting.
Thank you.
Yes, I mean, of course, agreeing with whatever was said earlier. I don't have a Bentley yet, but I did study international law, and there is a lot of happy space out there you can explore. I think at least 3 misperceptions need to be addressed about international law. One is, of course, that it is a very distant thing because it's seen through the layer of, the status between, and it's something which the diplomats do and the minister does, and how is it going to impact? So I think as teachers, we need to have particular lectures, disabusing these sort of misperceptions that no, when India signs the TRIPS agreement, its patent law changes and the prices of medicines will change accordingly, and it will impact you, individual citizen, it will impact. So that distance has to be first removed. The other important thing is to basically the big problem which I find, because I come from the social sciences, is that one of the biggest problems is that people want to treat international law like law. And it isn't. It's a special type of law. There is a certain politics to it, as was said earlier. And right at the outset, as teachers, I think we have to set that out straight, that this is an interface and you have to as much understand the politics of it. It's not just about the clauses and subclauses and what it is on paper, because the life of international law is really elsewhere. So that is the other thing. A third problem that I find sometimes in the classrooms is the focus on topicality, right? A lot of interest on what is happening in Gaza today. Again, that confusion of, IR or ILO being current affairs, which it is not. Reading the newspapers is not international law. There is a lot more, making yourself master of the tools, which you do through history, which you do through theory, where you step back and you have a very deep understanding of how issues have evolved. That is very, very important. So I think these 3 things we are still struggling to basically deal with these in the teaching of international law, which we need to figure out. I just want to say one last thing, that because there are students here also, that of course there are many other sources as well, but the Indian Journal of International Law is published also out of the ISIL. I think you are also there still on the editorial board. So I invite everyone actually to write for the journal, and till you write, to also read the journal. It's a good source, it's available, etc. So all the best from my side for those of you who will pursue international law in particular.
Thank you, ma'am.
Thank you, professors. Thank you, everyone, for displaying such enthusiasm. Now, let me take a moment to talk a little about our center and the flagship journal. So the Center for Promotion of International Law is dedicated in promoting excellence in research and teaching of international law, a field that has gained unprecedented significance in today's world. Additionally, the center is now taking the lead in publishing its flagship journal, the VMLS International Law Review, which features original work focusing on contemporary issues in international law. The confluence of international law, research, and policy is critical intersection where legal principle, academic research, and governmental or organizational decision-making comes together. This convergence is particularly significant in the context of the global governance, diplomacy, and addressing the complex transnational issues. Academic research in international relations, law, and related fields contributes to the development and understanding of international law. And this is where the VMLS International Law Review comes into picture. Finally, the moment has arrived where we call upon all our dignitaries, our Dean, Faculty Coordinator Shambhavi Thakur to finally release the journal. This brings us to a juncture where I cannot propose or ask my colleague to propose a vote of thanks before adding a bit of literature to whatever the session has brought about. So a little poem before I invite Professor Shambhavi Thakur. So the poem goes like, life on earth could be such fun, a world of peace for everyone, with all nuclear weapons straight down the pan, an organized religion subjected to a ban. The best place to pray would be at home. That way everybody would be left alone. No religion could be used as a pretext for war, and love would be international law. Now I would like to invite my strength, my colleague, who has been guiding and supporting me through and through, Professor Shambhavi Thakur, to deliver the vote of thanks. Over to you.
Dear distinguished speakers, esteemed faculty members and staff, guest viewers who have joined us online, and our cherished students, I, on behalf of the Center for the Promotion of International Law, extend my heartfelt gratitude for the successful culmination of the panel discussion featuring eminent professors Prabhash Ranjan, Professor Bharti, and Professor Archana Negi. Our deepest gratitude to our guest speakers for their insightful words. No doubt we are all leaving this room a little wiser, a little more meditative than we were when we entered it. We express our sincere thanks to the management, particularly our Chancellor of Vinayaka Mission Research Foundation, Dr. A.S. Ganesan, Dr. Anuradha Ganesan, the Director of Vinayaka Mission Research Foundation, and Mr. Suresh Samuel for their unwavering support and guidance. A heartfelt thanks to our Dean, Professor Anant Padmanabhan, whose guidance and advice enriched our endeavor. A special mention to the law school faculty and staff for going above and beyond in ensuring the success of this event. We thank them wholeheartedly. A series of special thanks. Special thanks to Dr. Faumina for her warmth, assistance, and meticulous coordination. Special thanks to the Media and Outreach Committee, especially Professors Gunjan and Idaya, for their valuable contributions in creating, publishing, and promoting the event. A special acknowledgement to Ms. Sheetal, the office wizard who is always ready to help everyone, for her indispensable assistance. A special thanks to Professor Nishant for his unwavering assistance and seamless coordination on all fronts. Dr. Shen Bagwali for seamlessly coordinating with the students. Mr. Senthil, the Chief Growth Officer of Vinayaka Mission Research Foundation. Ms. Sunita and Mr. Zee, who left no stone unturned in their enthusiastic support. The entire administrative staff of Dean's Office and Ms. Merlin for their support. Our students, whose eagerness and dedication inspire us to continue such endeavors. The Madras Management Association for the exceptional management and invaluable assistance in organizing our event. Last but not the least, Professor Nabila Siddiqui, whose unrelenting energy made this event possible in the first place. Thank you for all your collective efforts and turning this event into a resounding success. I am now requesting all faculties and Justice Dr. Daniel and Mr. Senthil to join us for a joint photograph. Thank you, everyone. I didn't talk about Justice Dr. Daniel.
Justice Daniel, please. And can we request the students to remain seated? Can we all rise for the national anthem?
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
Requesting all the students to be seated. Requesting everyone to remain seated while Dr. Winfred, Dr. Shenbagavalli, Professor Nishant to escort the guests for the lunch. Once the guests leave, the students can proceed for the lunch. But not just